This one is we're going to come in for but so far from the second, the top really Colorado Springs and Rapids right now. Yeah, now we'll win the first game. Yeah, there are 10 teams, 8 make the playoffs. So yeah, we'll win one and then we'll see.
Limits are much lower, so I just need
Yes.
Close now. If people could begin to take your seats, we'll get started in just a minute.
Bill, how are you, sir? I'm going to the deadline. I'm at the 7:25.
Every time I turn around, you're another one of these events.
All right, I think we're going to get started here. If we can have the last few sit down. Hope everyone had a great lunch. We're really looking forward to what the afternoon has in store for us. Without further ado, I'll turn it over to John Sallet to get the panel started.
Good afternoon. Let me ask the first and most important question of the panel. Is the microphone working? Yeah, okay, good. We're going to talk today about IP transitions, the social impact of networks, internet protocol transition, and the social contract for the broadband world. One ought to talk about this in the plural IP transitions, since there are more than one, affecting different kinds of networks. Let me take a minute before we begin just to frame one aspect of this on one kind of network that's very familiar, and that is the subject of discussion, and that's the classic copper telephone network in the United States. In its meeting in January, the FCC, which is where I work, adopted an IP transitions order. Maybe it's worth just to note it briefly, since that may frame some of the discussion. There were basically three parts. First thing the Commission did, acting on a petition from AT&T, was to authorize voluntary service experiments. A service experiment is an experiment where there's a changeover in the current operations of the delivery of circuit switch services to existing customers or new customers. So the Commission authorized and invited applications for these kinds of experiments. In so doing, and this goes, I think, to the title and perhaps to some of the discussion that will come, the Commission emphasized the importance of 4 enduring values that it said had to be in place during the experiments. As framed by Commissioner Rosenworcel, those include universal access, public safety, competition, and consumer protection. So to just take one obvious example, the Commission said no experiment goes forward that doesn't provide customers with access to 911 without regard to the use of the technology. Second, the Commission initiated the process of what are called targeted experiments, focused on one of the goals, the goal of universal access. One way to think about this is a series of proof of concept tests to see if it's possible to further understanding about how broadband can actually reach populations it doesn't reach. The example that the Commission discussed at length in its order, rural broadband. What are the assumptions about how networks are built in rural areas? What could be proven out through funded tests, in this case using universal service funds? Another form of R&D that the Commission adopted is ensuring better access or access to IP-based networks for people with disabilities. Why are experiments like this important? Commissioner Pai said this upon the adoption of the Commission's order. He said, "We need to see what works and what doesn't. Albert Einstein had it right. A pretty experiment is in itself often more valuable than 20 formulae extracted from our minds." In other words, the idea of the experiments is to get facts on the ground, to learn at a time when the Commission is thinking about but has yet to decide or even be presented with some of the big policy questions of the next few years. Indeed, to that last point, the Commission also initiated a data collection process to learn more about these different kinds of IP transitions. The order is only, one might say, the end of the beginning of the process from the Commission's point of view. One of the other things it said would be done was the creation of a managerial framework that will help the Commission decide when and through what proceedings it will decide some of the big policy and legal questions that no doubt everybody here will discuss. So today we have a very distinguished group with us. We'll proceed through the presentations in alphabetical orders. I won't go through people, but you can decide first or last name when you I won't go through the bios, which are extensive and impressive and are also listed in the program. And then we have presentations, discussants. We'll save time for Q&A, and there's always the first question goes to a student. One last point. I noted people this morning making clear that they were expressing their personal views, and I'm a governmental official, so I just want to say this. If during the next 90 minutes I tell a joke that doesn't work, I'm speaking in my personal capacity, not the other.
That could have gone either way, right?
Derek?
I think we shouldn't enforce alphabetical privilege. I think Kevin should get to go first because the W's are always higher.
Do you want to do reverse
Across stage.
alphabetical? I mean, we can negotiate that right here.
We'll have a multi-stakeholder process.
Yes, exactly right.
That's
That's exactly right.
Sure, I'll take that up. So I'll try to say a few different things. First of all, thanks to Phil and everyone for inviting me back here. I was at, I think, either the first or the second Silicon Flatirons conference, and have come a number of times since then. And coming here today, I felt this morning, despite how incredible the discussions have been already, somewhat unsettled. And I was trying to figure out why. And I think I realized I've spent my whole career, which now very frighteningly to me is about 20 years in this field, basically being an internet guy in telecom. And now here I am, all of a sudden being a telecom guy at an internet conference. And I don't think I've changed at all. I think the world has changed. And that's really what I think we're talking about on this panel. So because I'm somewhat unsettled and because I don't have to give a disclaimer, because shockingly I'm the first panelist who's spoken today who actually is a law professor, is actually a credit to the organizers. I can be provocative and surly if I want. So I'd like to suggest that this panel is about IP transition and social contract, and we really don't know what we're talking about on either of those fronts. So the first one is the transition. What is the transition that's happening? Jonathan's absolutely right. There are a series of different transitions. And I think it's important not just to look at it as a transition to IP, as a convergence to one protocol, because in some way that's something that has been going on for a very long time. Back in the mid-90s, I remember there were interesting technical debates about whether everything would converge to IP or everything would converge to ATM. That was really the discussion at that point, and we know the outcome of that. No one today who is building new voice and video networks is building them on some completely different protocol. This is the basic framework that everything is converging towards, although, as Dave Clark very helpfully reminded us in the first panel, that does not mean that all networks are the same. That does not mean that everything is the internet. Within that, though, there is an important transition, which is the transition away from the public switch telephone network. And so, if you take the standard definition of wireline switch voice service, in 2002, 93% of American homes got their telephone service via wireline switch voice service. In 2013, 25%. According to the FCC Technology Advisory Council, by 2018, that will be something like 6%. So at some level, that transition has already happened. But what hasn't happened is we haven't shut down the legacy network. So I think the real issue that we're going to have to deal with in this set of transitions is the issue, again, that Dave Clark raised in that chart he put up in the first panel, which is what happens to the backstop? What happens to the open network? Because the public switch telephone network has always been the open network environment. And it's incredibly healthy and beneficial and innovative and great that we are moving into this new world, which is a world that touches on vast areas that have largely been outside of the sphere of regulation. But it's much easier to do that in an environment where we can say, well, all right, we always have the legacy network to fall back on. We always have the legacy network to fall back on when the power goes out and you can use your wired telephone. We always have the legacy network to fall back on in terms of the FCC and state regulators and other kind of regulatory systems. And it's actually a hard question to think about what happens when that goes away. And it's the question we're seeing in lots of other contexts. It's, again, the question that we're seeing now in the net neutrality context that we talked about in the first panel. But it's a question we're seeing in lots of other fields as well. So in the paper that I did for this conference, I gave the analogy to car sharing services. So lots of debate about services like Uber that are trying to disrupt the taxi and car service business. And there's lots of extraordinarily good things those services do. However, they're not price regulated. So they charge more, and Uber has what's called surge pricing. So in times when the weather is bad, they may charge 5 or 6 or 7 times what they charged before. They don't have all the same obligations of insurance, all the same kinds of regulations for consumer protection that the existing taxi services have. And right now, their answer when they get pushed on that is, look, we're providing a service the market wants. If you don't like it, just take a taxi. So the question is, what if there are no more taxis? And the question for us in this transition away from IP is, what if there is no more public switch telephone network? So very quickly, let me just set out a couple things that we should think about in asking that question. One is, what is this thing? What is this thing we are transitioning away from? And it turns out that when we talk about the public switch telephone network, we mean a whole bunch of different things. So in an earlier paper, I came up with 6 different interpretations of what we mean when we say the PSTN, the public switch telephone network. It's a technical architecture, it's a regulatory arrangement, it's a set of business and market structures, it's the notion of universal connectivity, the notion of everything is connected to everything else. It's a piece of strategic national infrastructure, critical infrastructure and beyond. And it's the embodiment of a social contract. It's the embodiment of a set of values. And I think in this process, we need to look more closely at what exactly we're talking about and which of those things should endure. And if so, how, and which can fall by the wayside. Second point, this is a transition, but it is only the most recent in a series of transitions we've had in telecom. I counted 6 different transitions going back to the first period from the expiration of the Bell patents in 1894, which was the starting gun on competition in telephone service, up to the 1913 Kingsbury Commitment, which was really the start of government regulation of the old AT&T regulated monopoly, up through the 1934 Act, through the pivot in 1956 towards containment of the monopoly and hush-a-phone and the 1956 Department of Justice consent decree, up to divestiture, and so on and so forth. We've had a series of these transitions. Each one has been an arc. Each one has started in one place and ended up in someplace different. And each time it's destabilized the existing arrangement, and we've had to think about what are the values that need to be preserved. So I think that history can be beneficial, and just in my opening remarks, I'll just put down a marker. We should look back at those stages as opposed to assuming that, although there are many unique aspects of this transition, that the process is inherently unique. So what about social contracts? As Jonathan said, the FCC talks about these enduring values, and I think that's a really valuable thing to do. The values they came up with, I think, are very astute. But it's really important to remember something when we talk about a social contract. It's not real, right? There is no actual contract there. A social contract is a myth. Now, it's a myth in a very good sense. It's a myth in the anthropological sense. A myth is a set of stories that gives an organizing framework to a set of social activities. So talking about a social contract around telecommunications or what the telecommunications networks evolve into is a very healthy process, but it's a healthy process because it gives us a way to talk about values. It gives us a way to bring these incommensurable values into a positive conversation, a conversation that's purely about economics and competition and money types of things, when those values are truly important, and the decisions that we make, and the decisions that all these private actors make, have huge impacts on lots of values that are important at lots of different levels in our society. So we need to think about just what those values are and how to preserve them. So very quickly, because I know we want to be short in the opening remarks, looking at these series of transitions, the social contract values that get encoded, essentially the backstop of what obligations remain on an industry or some subset of the industry in these transitions, tend to serve one of 3 purposes. They are either a substitute for competition. We're not going to have competition or enough competition, so let's do something, for example, price regulation, to try to approximate a competitive market. Secondly, there are ways of creating competition. So, for example, we imposed interconnection obligations or wholesale obligations, resale obligations in the 1996 Act to open up the opportunity for competition. Or they address things that competition doesn't necessarily solve. So the 911 point that John mentioned at the beginning is an example of something that competition doesn't necessarily solve. The notion that you will have the choice about whether you want a phone that connects to 911 when you pick it up or one that doesn't, not a very good choice. We don't want to give people a choice that says maybe someone will, your babysitter will pick up the phone when there's an emergency and no one will answer. And you say, well, you chose to not be able to reach an ambulance. That's not a good choice. There are other things that may have that similar character, where competition may not be a solution to all the problems. We should think about what those are. The last thing I'll say is that there's a bunch of different pieces. There's universal service pieces, there's public safety pieces, and so forth. I think that one set of social contract-like obligations we should think about resurrecting is open networks. So as I was researching for this paper, for this conference, I started just looking at large articles that talked about social contract and telecom. And I came upon one that I remembered reading but hadn't looked at in a while. It was a 1986 article with the primary author, which was Mark Fowler, who was one of the Reagan-era FCC chairmen. It was called Back to the Future. And this was in the era after divestiture of AT&T, but before the 96 Act, when there was lots of discussion about deregulation, letting the baby bells into long distance. And he essentially proposed a social contract, the idea of which was trials of deregulation, but with a backstop. And the backstop was not, say, price regulation. The backstop was open network architecture, which was a process the FCC had put into place as part of the Computer 3 process to evolve the telephone network into a modular open network. Now, Fowler's idea never got any traction. And the O&A process completely collapsed and was never successful. So you might say, why am I bringing this back? Again, I'm not academic, so I get to post I think if we look forward, and so this is where I'll close, again, if we want to, at least I certainly want to, be talking about this in terms of the future, all this incredibly exciting technological development like what we heard about in the last panel, as opposed to looking back to the legacy regime, the legacy networks, we need to think about the value that open networks have in this ecosystem that has emerged over the past couple of decades around the internet. And open networks is one of these code words that, of course, mean lots of different things to lots of different people. So what I'm suggesting is this should be the start of an investigation of just what that means. But I think it means something more than what we've been talking about in at least some of the net neutrality discussions, which is to say the networks are a black box, just make sure what goes in and what comes out is the same. I think we need to think about lots of different points where networks could be open. More and more we're seeing the controversies and the difficulties around things like hearing, around things like spectrum, these different points on the network. And I think we need to have a new set of definitions about what openness of the network means so that we can figure out how to carry that forward into this world that we're going to, which is tremendously exciting, but which also justifiably is really scary in terms of what we're giving up.
Thank you. Catherine?
Thank you. Great. Well, thank you very much. It's a great pleasure to be here, and thank you to Phil for the invitation. I've had the opportunity to have Paul out to speak to my class at Santa Clara when I was a law professor there, so it's a great privilege to be here at Boulder and see so many longtime friends and make some new ones, so thank you very much. So I'm speaking here with several hats. I'll try to distinguish when I'm speaking for myself as opposed to in an official capacity. As a commissioner of the California Public Utilities Commission, I believe I'm the only person in the room who has voted to regulate Uber. And I am also a member of NARUC's Telecommunications Committee. I am the vice chair of NARUC's Telecommunications Committee. And now also there's great interest in another committee I am on. I am a member of the Federal State Joint Board on Advanced Services, the 706 Committee. So I'm the state policy chair of the 706 Committee. So after the recent net neutrality decision, we expect our committee to have a little more action. So, so just a brief commercial for that. We do expect to be having at the NARUC meeting, which will be in San Francisco in November. In conjunction with that, we plan to host a conference at Santa Clara and would love to bring in the academic voices to help us with our work on the 706 committee. So we'll definitely be inviting you all to participate in that. So look for news of that. So a couple of things I wanted to mention. I loved Kevin's draft paper on Uber, and apologies for not circulating my draft. I got a terrible case of bronchitis. And a couple of things to think about with Uber that I think are instructive when we think about the telecommunications network. The California Public Utilities Commission has a vast set of jurisdiction. We were originally the Railroad Commission, and then reconstituted in 1912 as the California Public Utilities Commission, moved to San Francisco under the California Constitution to try to diminish the influence of Leland Stanford and the other railroad robber barons. He, of course, had a little beachhead on the peninsula, so that didn't work out so well in terms of diminished influence. So we have a wide range of jurisdiction. We still do rail safety, rail crossings. We have jurisdiction over charter party carriers, which is primarily party bus jurisdiction. But we used our charter party carrier jurisdiction to basically claim that Uber, Sidecar, Lyft, and their ilk fell under our jurisdiction and declared them to be transportation network carriers because either they were under our jurisdiction as charter party carriers or they were illegal gypsy cabs. And so we actually had a enforcement action pending against them, as did a number of cities. And so this actually created a way for them to legally operate, and where we created duties, including duties regarding insurance and also disclaimers. So our rules about insurance do require them to cover the first dollar personal injury. It also limited their disclaimers so that they cannot disclaim liability or insurance or other duties. We are dealing with a petition for rehearing that they filed, arguing that we have a lack of jurisdiction because they are an IP-based service, although they and others have admitted that their whole purpose is to put real cars into the real world that have gotten into real accidents. And very sadly, we recently have had one person killed on New Year's Eve by a driver who at the moment was not driving for the transportation network carrier, but was broadcasting as available. So it creates very interesting questions about who is liable. Also, the industry had long encouraged people, if they got into an accident, to file a claim against the driver's personal insurance, which the insurance commissioner, I and my colleagues are concerned induces insurance fraud, because most personal insurance policies have a livery exclusion. So if you're driving for hire, then you would not be covered. So much so this is a concern that our California insurance commissioner is putting out an alert, also advising drivers that the transportation network carrier insurance doesn't cover their collision damage. And we're also working with the industry to try to now create some sort of rider that people could get to allow them to be the drivers. So the reason that I'm going into all of this is that I think that it raises a number of issues, including, both what happens when there are no taxis and what happens when an IP service whose purpose is to put real cars out in the real world, tries to claim that it's not a network service and that it's just an IP service. So we sometimes have to look behind the IP to see what's really going on. And I wanted to continue with the theme of values. So I think it's great that Jonathan also started with values, because the title of my talk is about principles for 21st century telecommunications regulation. And so I wanted to talk here in my role as the vice chair of the NARUC Telecommunications Committee, and also I was a member of NARUC's Federalism and Telco Committee. So along with my fellow state commissioners, we were asked to update a white paper, a 2005 white paper on the role of the states, and look at key principles that could help us guide telecommunications regulation in the future. So we had a very diverse committee representing states that are predominantly rural, predominantly urban. We were chaired by Orji Siagu, who is with the Michigan Public Service Commission. We had members from North Dakota, including Chris Nelson, who is now the chair of the Telecom Committee, members from Florida, Vermont, Idaho, and my co-chair, Paul Schalander, a great variety of states. And when we got together on the very first day that we met, I suggested that instead of continuing the debate about Title I, Title II, that some of the staff members said, okay, this all has to be rooted in this title thing, that, I was like, okay, time out. So when we talk about networks of the present and future, I suggested we should focus on principles and values. And so our principle-based approach, the principles actually, I'm proud to say, I suggested, the committee unanimously agreed before lunch. Republicans, Democrat, our first day of meeting in Washington, D.C., unanimous agreement before lunch. So much so that we were like, wow, now what do we do? So when we spent the next 9 months trying to write up a white paper on a unanimous agreement, which has been published, and NARUC unanimously passed a resolution adopting the principles we suggested. So many of the principles overlapped with the values that Commissioner Rosenworcel identified and that the FCC Commission unanimously adopted, led by Chairman Wheeler. So our proposed principles that we believe should guide telecommunications regulation in the 21st century include consumer protection, network reliability and public safety, competition, interconnection, universal service, and the three additional principles are regulatory diversity, evidence-based decision-making, and broadband access, affordability, and adoption. So I wanted to talk a little bit especially about those additional three principles, but also to give some examples of why this principle-based approach, I believe, is important. The FCC also agreed and specifically identified the principles of public safety, universal service, competition, and consumer protection. And I would suggest that as you look at, for example, the IP transition order released just last week, that they basically have assumed or recognized the other principles, but I think it is important to specifically articulate them. So in the IP transition order that the FCC released, one of the things that they mentioned is that the goal of these experiments is to conduct these experiments where they are permitted by federal and state and tribal law. So there's an expectation that any experiments are going to be consistent with local and state laws. So that's important. I'll come back to that. But that they wanted to also preserve the positive attributes of the network that customers have come to expect. And they specifically said that preserving network values advances technological progress. And one example is, for example, 911, that, having networks that can reach 911 is also going to be critical to being able to adopt new networks. The House Energy and Commerce Committee also recently asked for stakeholder comments about structures or principles to guide Communications Act review. And one of their questions was, does the current Communications Act, which is structured around particular services, does this structure work for the modern communications sector? And if not, what structures or principles should the Communications Act revolve around? So NARUC has submitted comments that have recommended considering the principles that we have adopted as guidelines as we continue to look at the Communications Act. So I wanted to mention a couple of manifestations of why I think these principles are important, and some of these have also been identified by the FCC in the IP transition order. So one example is the very unfortunate epidemic of call completion failures that really started in mid-2001. So for those of us who've had the privilege of working at the FCC or at a state commission, and indeed for carriers, call completion failures on a massive scale are unthinkable and anathema to everything that a telephone corporation and telephones are about, right? A telephone is not just a pretty thing you put on your desk. A telephone that can't make calls is just a brick, although you might be able to do other things with it. And so call completion has always been not just a fundamental expectation, but a legal obligation, as I will mention. So part of what brought to light the whole issue about call completion failures was the role of the states, as well as trade associations and rural carriers who highlighted this epidemic. And so what they were highlighting is that in many states, including states like California, people think of California as a very urban state, and I am from Los Angeles, from East LA, so very, very urban place. We have 3 of the top 10 largest cities in America, Los Angeles, San Diego, and San Jose, which I would add is a bigger city than San Francisco. But we also have our rural areas are bigger geographically than the state of Kentucky, with a larger population than the state of Maine. And when you talk about our rural areas, looking at the beautiful Flatirons, which you can't see today, but I did see yesterday, we have the huge Eastern Sierra Range, Yosemite. So soon I'll be going to a public participation hearing looking at our state rural high cost fund in a place called North Fork, which is near the entrance to Yosemite. And we have 2 rural carriers in that area. We're also going to be having a public participation hearing in Wairika, where we will be able to get customers of both Siskiyou Telephone and CalOR. We were debating whether to have that in Wairika or Weed, California, home of Siskiyou Community College. We'll also be going out to the Gold Country. So we have vast areas that are rural areas, some of which have 110-foot tall pine trees with national forests where you can't cut down the trees. Huge canyons. So what this means is satellite doesn't work in a lot of these places at all, that there is no cable. Wireless often doesn't work. The tall trees and pine needles also tend to scramble a lot of signals. And that you have a lot of places, as much as we talked about who still has plain old telephone service, actually the CDC data says that in California, half of all people still have plain old telephone service. And when you look at some of our vital emergency services, like some of the watchtowers that we have for fires, many of them are only hooked up through plain old telephone service. Some of them also have radio. And it's absolutely critical that you have call completion, because when you look at fires like we had the terrible Rim fire near Yosemite, when you have a fire that big, it was one of the largest fires in California history, there are a lot of resources that are coordinated out of Sacramento from CAL FIRE, the California Emergency Management Agency. So the entire concept that a call from CAL FIRE in Sacramento to a rural telephone company would not be completed because of something that happens in the middle by a carrier is anathema to public safety and dangerous, and I think not something any of us want. So the states, as well as several organizations, also brought to the FCC rulemakings and petitions for enforcement about call completion. And so the FCC has addressed this in a number of its different proceedings, including the intercarrier compensation proceeding, a couple of petitions and orders relating to call completion, an enforcement action on call completion, and then just recently another action requiring data gathering relevant to call completion. And I would note that under that data gathering proceeding, which was led by Acting Chairwoman Clyburn, that they also imposed the data gathering obligations on VoIP carriers and specifically extended the duties to VoIP carriers because they observed several things. One, they didn't want to create a perverse incentive for carriers to contract with VoIP carriers who, if they were not subject to call completion duties, could then obviate the rules. So that would be a problem. And one of the interesting things is that the FCC used its ancillary jurisdiction, saying that this is actually a classic example of ancillary jurisdiction where even though they didn't decide whether or not these VoIP carriers were common carriers, they said that their practices were affecting common carriers. So I think that it's an important set of actions that the FCC has taken. And I also wanted to mention the state roles in this. So several states have legal duties for telephone and telegraph carriers to complete calls, even though we no longer have telegraph carriers. So for example, California Public Utilities Code 558 requires every telephone corporation and telegraph corporation operating in the state that it shall receive, transmit, and deliver without discrimination or delay the conversations and messages of every other such corporation with whose line a physical connection has been made. So there has long been a statutory duty that is in our Public Utilities Code, and there are similar codes that many other states have that make call completion not simply a matter of social compact or good network behavior, but a legal obligation. So the last thing I would like to close with in talking about some of these other sets of principles, including evidence-based decision-making, is I think evidence-based decision-making is something that the FCC almost assumes in the IP transition order. And actually they say over and over again that they want evidence. And when you look at, of course, the administrative law rulings and the reviews of FCC decisions as well as State Public Utility Commission decisions, there often is an examination about whether or not the decision-making body engaged in rational decision-making, including evidence-based decision-making. So the reason I have my phones out here, plural, is that I wanted to give as an example of this. One of the things that the California Public Utilities Commission has developed is an app. It's called Cal Speed, and it's available on the Android marketplace. You can download it for free. And what it does is that it tests the speed of wireless connections wherever you are, or whether or not there is a connection. So actually we find out here in this room we have a download speed of 8.8 megabits per second, but this says the upload speed is less than 1 megabit per second. So in California, we have a California Advanced Services Fund. And so for our State Advanced Services Fund, the definition of underserved, which allows us to consider whether or not the applicant is eligible for state money, is 6 megabits per second down and 1.5 megabits per second up. So right here in this room does not pass the up test, so we'd want to go outside. But this is also important because recently, for example, some applicants for our California Advanced Services Fund for an area in the Eastern Sierra near Yosemite have applied, and the wireless maps showed that it was covered. And using our app, they got people out there and tested and found large areas which had zero coverage. So I know that this is something the FCC has been trying to get at for a long time, and so this is a way to get the evidence for ground truthing. So we all remember back in the day when the FCC assumed that if one place in a zip code had internet, that the whole place had internet. You've gone down to the census level, which I know that at the IP transition they talk about the census block level. This lets us go down to a much more granular level to create that evidence that really can be the basis for sound decision-making. So I know we have several panelists with that. I think I will leave that because I think I've touched upon areas about the role of the states and thus the importance of regulatory diversity, as well as the importance of broadband access, affordability, and adoption, which is our last principle that we explicitly have proposed, and with emphasis on access and affordability, as well as adoption being fundamental principles for the next generation of networks. So thank you very much.
Paul?
Great, thank you. So first, thanks to Phil and Paul for the invitation to be here. Thanks to Jonathan for moderating the panel. I took the role of being a presenter very literally and put together a presentation. So I have a few slides. I guess I'll stand up so I can see what I'm saying. So I have three propositions for discussion now. We're going to go into panel discussion, audience discussion too, which I hope are relatively non-controversial, but let's see. So the first is that the social contract hasn't really changed in an IP world. The goals stay the same. The second is that even though the goals are the same, what actually has changed is the government's ability to hold up its end of the social contract. And what does that mean? That means that the rights and responsibilities of providers and consumers and other stakeholders in an IP world are going to be very different. And that could be for better or worse. I think some people would say, well, the IP world is much more competitive. It needs much less government involvement. That's a good thing. Some people would say, well, there's still bottlenecks. There's still areas that need government intervention, and so that's a bad thing. So I'm going to quickly just spin through these three observations. So the first is that, so everything I know about political science I learned from Wikipedia, but this is my sense of stakeholders involved in an IP world. So there's essentially three. There's the providers. So in an IP world, not just the infrastructure providers, but also people providing platforms, app stores, and so forth, and also applications. There are consumers, could be individuals, could be households, also businesses who are buying both retail and wholesale, and the government at the federal level, all the different agencies involved, and the state level, and the local level also. And so The interactions between those, let me propose that there's only one of them that's actually a social contract, which is the interaction between consumers and the government. So consumers give up, I guess in the classical Hobbesian sense of the social contract, consumers give up, that was from Wikipedia, by the way, it sounds very good, sounds very good. I said in the Hobbesian sense of the contract. Consumers give up some of their rights in return for the government protecting them. So I give up my right to hit Jonathan, and in return, the government,
And I appreciate it.
temporarily, just to be clear, and in return, the government, as an institution above, will use its force to protect me and Jonathan both. And so I would say there's a social contract, therefore, between consumers and government. Consumers look to the federal and state agencies in the realm of telecommunications to preserve the goals that Kathy and Jonathan have both mentioned. Between consumers and providers, there really isn't, right? I mean, providers hold out different offerings in a competitive marketplace. There's competition, and consumers choose what offering they want, if any, and then there's a contract between them, formal or informal. Between providers and the government, I think it varies very much country to country. So I've had the privilege of working in telecom in several countries, and I think in some countries there is something of a social contract between government and providers. So in some countries, the government, the equivalent of the FCC chairman, might say, look, why don't we all adopt this standard? It's probably not in totally your self-interest, but it's good for the country. Why don't we roll out this wireless connectivity, WIBRO, fiber to premises? There may not really be a business case for it, but it's good for the country. We should all do it, right? I think here in the US, we don't really have that kind of industrial policy. Again, I'm not saying it's a good thing, but it's just different. We don't have that kind of industrial policy. And therefore, the relationship between providers and the government is really more adversarial and more based on regulation, right? So regulation, the point of it is generally to make zero-sum decisions in the public interest. So what does that mean? Well, one of the interesting things, to me at least, about the IP transition, so look, people started talking about packet-based networks replacing circuit networks in the 50s, right? Paul Baran said, packet-based networks are the way to go, much flatter, much more resilient. In the 60s, I think IP was invented, right? I mean, Kahn and Cerf, right? So we're now 55 years later talking about the IP transition, right? And why is that? And I think it's because the IP transition is being driven, as you would expect, by market forces. It's being driven not in a social contract way between providers and the government. It's being driven by providers who now find, totally reasonably, that the IP transition is in their business interest, right? So either it creates new revenue opportunities, and it reduces capital expenditures and operating expenditures, and it can lead to reduced competition and reduced regulation. So I'm a provider. It's in my business interest now to transition to IP, and also to obviously turn off legacy networks wherever I can in order to save cost. Totally makes sense, totally in line with the incentives and motivations of the providers. That leaves, though, I think, many of the government agencies in a bit of a tricky position, because if you accept the first premise that the goals of the social contract haven't really changed, the ones that have been mentioned a couple of times now were in the FCC document release: public safety, ubiquitous and affordable access, competition, and consumer protection. The government role now is to figure out how to keep meeting those goals that presumably consumers still expect in this new world of the IP transition, where they have limited regulatory levers. So what can you do? You can change the rules. So you can say, here's a rule that used to protect competition in the old world. How do we change it now to protect it in the new world? Or do we need it at all? Maybe we don't need it. We can just get rid of it. You can try and change incentives. So think of something like the Universal Service Fund, right? So $4.5 billion that used to be going to try and support voice services that's being transitioned now to support IP broadband services. Or you can do things like try and increase competition, right? So how do I increase competition in IP world so that I don't need as much regulation and there's a competitive marketplace and consumers can just choose whatever services they like? So I would say the difficulty a little bit is that the government's ability to do those things has changed in IP world. In particular, I would say it's changed in three ways, and I'm using jurisdiction here not in the legal sense, more in the sense of authority, so sort of political and economic and legal. So three relatively clear things, I think, that have changed in the IP world, right? So we have now, in this provider corner, not just the platform network providers, but as I mentioned, we also have applications providers, we have app store providers, and there's limited jurisdiction over those players, right? I think one of the points that the carriers repeatedly made during the net neutrality discussions was, well, why is it that an app store run by a provider should be under a different set of regulations than an app store run by Apple or Google, right? There's a different set of jurisdictional hooks that the government has over those different providers. The second is that over areas where there's an emerging bottleneck, again, there hasn't really been either the legal authority or the regulatory precedent for regulating those often. And so you think about voice interconnect. There's obviously been a long history of regulation of voice interconnect. People can argue about how, when you go to IP voice, which of those obligations should remain. But the precedent and the norm is there for regulatory intervention. Not really true for peering, right? I mean, the norm for peering is no intervention. It's kind of worked. It's worked to date. It's worked very well to date, it seems. Right? And so even if now something is, if you believe that now something has changed and there is a market failure there isn't really the norm for a government intervention. And it's difficult to break that kind of norm, even aside from the legal authority question. Similarly, a lot of my sense is that a lot of regulation that is designed to support other goals of the social contract, like competition, it's actually been written in a technologically specific way, so that if you want to keep, even if you want to keep supporting and meeting the goal, you're kind of in trouble because it was written with a set of competitors in mind. It wasn't really written with respect to platform providers and application providers in mind. So there's that kind of inherent difficulty in translating regulation that's been written based on technological silos. So finally, what does this mean? I think it means that you have the same goals, you have difficulty in upholding them. It just means that people need to have different expectations in an IP world, right? So as Kevin said around 911, maybe actually I should have the expectation that when I dial 911, the provider won't know where I am location-wise, right? Maybe I should have the expectation that when there's a storm, my phone isn't power backed up. As long as it's clear, it seems like possibly it's a choice. Maybe as a society we say we don't want people to have that choice. I would say it's not completely obvious. It should be transparent, but it's not completely obvious which goals we actually do want to translate. More broadly, and this was, I think, brought up a little bit this morning, this is just some numbers we put together. If you take the annual revenue of the telecom sector writ large, it's about $400 billion a year in the US, ballpark. And so one thing to note is that if you think about all the different parts of the landscape, wireless, pay TV, fixed services sold into businesses, broadband for residences, and then voice service at the top there. The voice service that we're spending a lot of time talking about in the context of an IP transition is a relatively small part of the annual industry, right? It's about 5% probably remains on TDM if you take out cable voice services. And there are IP transitions going on in the other 95% of the industry that are probably worth talking about also, right? Because it's not just about IP voice. I won't go through all of these just in the interest of time, but a couple that I think are maybe worth highlighting is, I think Dave Clark mentioned this morning, but in cable, there is this transition from QAM to IP video. In 5 to 10 years, all video will be IPTV. That obviously that's a big IP transition that's happening, that obviously has big regulatory and consumer implications, worth noting. And then the other one perhaps I'll mention is on the enterprise side, where there are a lot of issues around competition that has been based on either wholesale services, wholesale TDM services, wholesale legacy services, or wholesale facilities, so the actual physical copper connection. And again, as we move to an IP world, the regulatory frameworks for those are very different, but the implications for competition in an IP world, therefore, are very profound, right? Because unless you translate those goals and regulations to the IP world, which you may or may not want to, but if you don't, then there's certain implications for the other goals of the social contract that we're implicitly making. So with that, I'll stop and maybe hopefully we'll discuss some of this.
We will. Derek, you asked it to be in reverse alphabetical order. Do you regret that decision?
Be careful what you ask for. It's always hard after lunch, right? Especially being the last speaker. But I want to thank Phil and Paul for inviting me. It's really a great pleasure to learn from such a smart and diverse group. And I have to say, the big takeaway so far is that I wish I had jurisdiction over the charter party bus, right? That would be, I mean, I would inevitably abuse my power, but still. So in this short talk, I'm going to do something in which lawyers and law professors excel. I'm going to spend time nitpicking, right? I'm going to identify problems with a generally laudable larger proposal, here the shift to an all IP world. And I want to suggest that as we think about these, the sort of panoply of concerns that we've discussed so far today, it may actually be helpful to classify or group these problems into two rough camps, just for sort of clarity purposes, which I will call foxes and hedgehogs, right? I don't have Uber, but I do have mammals. And so the British philosopher Isaiah Berlin used this framework to try to divine similarities among thinkers. And he borrowed the concept from a Greek poet who observed, the fox knows many things, but the hedgehog knows one big thing, right? And so I tend to think of a hedgehog problem in this space as something that's predictable, it flows directly from the transition, and it's largely invariant across contexts. Thus, a solution to a hedgehog problem should work in most, if not all, circumstances. By contrast, a fox problem is inherently contextual. Its effects are indirect, depends on the facts of each case, and so fixes for foxes must necessarily be more tailored, and they're harder to envision in advance. So I just want to briefly sketch three of these types of problems with the IP transition that maybe we're thinking about. First, the decreased resilience of a monolithic protocol. That's a hedgehog problem. Second, the destabilization of universal service arrangements. That, in contrast, is a fox problem. And then lastly, the disruption of established models of constitutional protection for speech. Also a fox problem. Let me start with resiliency. So the obvious change of the IP transition is the reduction in diversity in part of our communications architecture. So obviously different media simply become different applications. And this largely beneficial shift does, in some sense, make communications less resilient. Pre-transition, when Hurricane Sandy hits Brooklyn, locals in Bay Ridge with copper-based phone systems still might be able to communicate, right? Since their phones could potentially draw power from the batteries of the central office. Post-transition, either natural or human-created disruptions to IP will affect voice along with a panoply of other applications. And it turns out these disruptions are not merely theoretical. In 2008, Pakistan Telecom managed to accidentally reroute a significant share of YouTube's traffic to its own network because they made a mistake in configuring their border gateway protocol routes. In 2010, China Telecom briefly did something rather similar, not clear if it was a mistake or deliberate. And in December 2013, almost certainly deliberately, unknown attackers used BGP to divert traffic away from its intended destination to route it through Belarus and Iceland for purposes unknown. So, as always, monoculture has significant drawbacks as well as benefits. And I think that there are two possible mechanisms for mitigating this sort of problem. One is to actually keep around some of the old stuff. Maintain legacy equipment, particularly in areas such as emergency services that need to be a little bit more failure-proof. And second, to encourage diversity at other layers of the network. So this is a classic hedgehog solution. You have one big idea, maintaining some heterogeneity that solves many problems. Second, and the kind of focus of our panel today, is that the transition is going to unsettle at least certain parts of our social contract. And I would argue it does so by bringing different sets of American normative commitments into conflict. So we've accepted, for a variety of reasons, that certain basic technologies, most prominently voice, ought to be universally available either at no cost or quite low cost. And in contrast, other parts of the world, we've decided that broadband access provisioning ought to be mediated in our default fashion, which is via market transactions. If you can pay for it, you can have it, and otherwise, you can't. As the two technologies converge, inevitably, these different approaches clash. And so this, I think, is a fox problem. It involves multiple, overlapping, sometimes conflicting moral claims that have to be resolved in contextual fashion. So I think Kevin's paper and Paul's presentation eloquently cover similar territory, so I'm not going to tarry here. But I want to make two brief suggestions for thinking about this. One is that voice is not necessarily the right model for the social contract. Rather, what we need is higher order conversation about what are the sorts of capabilities that all Americans ought to enjoy, and second, what are the mechanisms by which we should pay for those. Somewhat more practically, in a kind of minimalist fashion, we might aim during the transition for the small goal that the change simply ought not to be regressive. that the transition should not make the least affluent worse off as a sort of bar for gauging success. So lastly, the transition, I think, is going to press home some lingering, somewhat dormant questions about constitutional protections for freedom of communication. Medium-specific treatment of speech no longer makes any sense when the technological and historical justifications for that variance disappear. And in particular, I think that something that the courts and policymakers will have to grapple with is the lack of careful treatment of listener interests in free speech jurisprudence. So if we think about the triad of speech interests, speakers, government, and listeners tend to get short shrift. We just don't have a well-developed right to receive information in US law, in contrast to other parts of the world. And I think that, interestingly enough, the network neutrality debates highlight this problem. So if you have differential treatment of content across a network, such as blocking in its kind of crudest form, it doesn't necessarily violate speakers' rights. You don't have a constitutional right to reach any particular speaker. And there's obviously sort of no effective way to bring a claim against a service provider in the first place because of the state action doctrine. There's simply no state action at this particular point. And indeed, as Verizon argued, although the DC Circuit didn't really treat it much, that if anything, rules that seek to protect listener interests actually cut in their favor. They cut the other way. That in fact, if you have network neutrality rules, these in fact are state action that impinges upon ISPs' rights to determine in editorial fashion what speech they wish to carry. So I think that this highlights that free speech jurisprudence is going to have to deal with two difficult challenges: state action and balancing interests. On the first point, I would argue that what we need as development is the idea that in defense of a regulation, the government ought to be able to raise in a sort of third-party fashion listeners' interests or listeners' needs as a constitutionally cognizable interest. Here, in fairness, in doing so, the government ought to actually have to show evidence of actual demand, something in contrast to the PEG channels, for example, that listeners actually are interested in the material that's subject to regulation. So that one is at least conceptually straightforward. Balancing interests is much harder, right? That's what makes this area a Fox problem, since the right answer will inevitably vary case by case. But I do want to offer two tentative suggestions for guideposts that courts could use when they're engaged in this type of balancing. First, that listeners' alternatives are key. So as listeners have an increasing set of options for broadband access, the impingement on their rights from restrictions such as blocking diminishes. Obviously, this necessitates both quantitative and qualitative analysis. So if all the providers impose the same restriction, you as a listener don't really have other options. And second, that in kind of classic con law sense, that what we ought to do is take a look at the fit, right? That the fit between the stated purpose for restricting communications and the implementation of that rationale is quite important. So the less reliably a legitimate rationale is instantiated in practice, the less constitutional leeway would be afforded. So if, for example, Comcast decided once again to block BitTorrent due to bandwidth concerns, it would be important to examine the company's treatment of other bandwidth-intensive applications. So just to close, I think one interesting, subtle advantage of the IP transition is that it forces us out of familiar patterns of thinking and requires us to re-examine why the goals and purpose for how we structure areas from emergency services to universal service obligations to free speech protections and why they're configured in the way that they are. And my hope is that this kind of rough cut, this rough grouping of problems such as either foxes or hedgehogs will enable us to see which solutions are readily extensible and which are more situation specific. So thanks very much, and I'm looking forward to the discussion.
Thank you. Len, do you want to go first among the discussants?
So, good afternoon. Let me start by thanking Phil for pulling together a great conference with great folks, and thank you, Jonathan, for hosting, and thank the presenters for pulling together some very interesting, thought-provoking presentations. I think I would like to make 3 points, and the first is at the outset, I want to make sure you understand you're not going to hear a question from me or a dispute from me about the importance of values. I think this industry has always supported some key values, and going forward we'll need to continue to support those key values and intends to do that. I think the real question for us is how do we do so most effectively in light of the marketplace that exists today, not the marketplace that existed yesterday. The approach was fairly straightforward when you had a stable monopoly telephone system, right? Policymakers would divine what the right regulations needed to be. They would impose those obligations on the monopoly provider. The provider would translate those into marketplace effects that all consumers would experience. That's become much more complex today. And today, with a multiplicity of providers trying to impose obligations under the current framework, distorts competition, impedes and misdirects investment. And it's not going to produce the desired effect in the marketplace, because what good are consumer protection requirements if they're not reaching all consumers? So I argue we need to take a completely fresh look at the market. I think with fresh eyes, we realize we can achieve many of our values through operation of the market with less regulation than we've had historically. And this should be our preference and inclination. I really agreed with and enjoyed much of Kevin's paper, which I read earlier, but I was concerned when the conclusion talked about the open network architecture framework. And I realize you're not talking about bringing that framework back, but using it as a model going forward. And so I want to share an anecdote. About 20 some odd years ago, I was AT&T's lead attorney on the computer inquiry proceedings and the CEI obligations, which were the O&A analog that attached to AT&T at the time. And in one respect, this was terrific. It enabled me to get out of the office. I sat down with our engineers, our scientists, our product development people, and it was terrific. And those people were very focused on innovating, creating products and services that benefited consumers, reduced costs, created greater efficiencies, but that wasn't my job. My job was to come with them and help them re-architect their services so they would meet these very detailed government requirements that were established in Washington. Now, I'll tell you, for personal experience, absolutely harmed consumers, absolutely imposed costs, distorted service offerings. Some services never made it to market. Now, I'm not saying that's wrong. The government is free to impose these types of costs when there's a countervailing benefit, right? And in a world of a monopoly telephone provider, you may make the argument that these types of regulatory costs are warranted given the benefits you're going to drive from the regulations. That type of balance, however, is a lot harder to find today when you have lots of competition in the marketplace and you're using a technology like IP that's hyperconnective. So this is true. So today we talk about open network architecture. Our markets are open. Our networks are open. If anything, we're opening them as fast as we can. We're opening APIs. And that's not going to change, because if it did, we'd lose customers. But it's not just about the openness of the networks. And I want to turn to just another illustration about another aspect of a value that I think is important. And Derek didn't mention, but in your paper you made the point that you thought network disaster recovery was a role for the government because there were inadequate incentives in the marketplace for either consumers or providers to provide that network disaster recovery. And I want to submit that the facts don't show that. If you look at the marketplace today, I mean, just turn on the TV and you see the debates going on around who has the most reliable wireless network, right? It's a competitive differentiator. So we spend billions every year in making our networks more reliable, more resilient, secure from cyber attack. And we compete on that. We compete on that front. We tout that, and you can see the accolades the company's getting today for all the money we put into those features of our network. But I want to also illustrate with another example. In addition to those types of investments, AT&T has a network disaster recovery program. We've invested over $600 million in that program over the years. It entails at least 95 tractor trailers pre-deployed around the country, chock full of technology. There's another 15 or so Colts and emergency communication vehicles. There's some support vehicles. There's 100 employees assigned to this task. We routinely drill on these operations. And to give you a sense of what's done, after 9/11, AT&T brought these trailers to the Jersey side of the Hudson River, tapped into undamaged fiber, and used free space optics across the river to help restore service in Manhattan. Now, that was something the private sector driven by competition did. That wasn't a government role. That was a private sector innovation because we needed to compete in the marketplace. So that's not me saying my third point, that we don't need regulation. I think there is a role for regulation. There may be a role for regulation. What I'm arguing is it should not be our first reflex. I think as Commissioner Olhausen reminded us this morning, let's say, well, what's the harm of some of the things we see going on? And if you do find harm, can antitrust deal with it? If not, if you need regulation, then we have to come to it with fresh eyes. There has to be network, provider, platform neutrality in approaching these rules. Because if the rules, as I say, are going to really have an impact on consumers, and that's their goal, these social objectives, they have to be applied all across all providers today providing similar or comparable services. So you think of text to 911. Having the ability of wireless carriers to provide emergency text capability to 911 is great, until you realize over-the-top providers are increasingly taking what looks like texting business. Consumers don't distinguish. They see it as all the same. So you need to look at these obligations and say, if the market doesn't solve the problem, how do we define and tailor regulations in a way that does in the new world, not the old world? So to close, let me just repeat the 3 points. Values should and will be maintained. Our first approach should be to meet these objectives through operation of a competitive market. And where regulation is applied, it needs to be applied and designed rationally to achieve its objective given the marketplace that exists today. And with that, I'll pass on.
Thank you, Lynn. Anna?
For stealing most of my talking points. So thank you, Phil.
He has more, Anna, if you need them.
That's what happens when you get to go first. And thank you, like I said, Phil, thank you, Jonathan, and thank you to the speakers for the very thoughtful presentations and papers. You didn't get to see the papers, so you didn't get to enjoy them, but they are very good. But I particularly want to thank Derek for his paper, because people who know me very well know that I use the fact that I wasn't raised in this country for my maybe more limited vocabulary or not knowing the definition of certain words. And your paper made me go to the internet more than any other paper to look up certain terms like congeries and deontological, which congeries, by the way, means a jumble, and deontological means something about moral obligations, in case so now you have benefited from my benefiting from your vocabulary, so thank you. I also want to congratulate you because you also managed to wrap in Duck Dynasty into your constitutional analysis, which I thought was a very nice way to do that. And then finally, his paper really is so charming to read that halfway through it, I started imagining that Benedict Cumberbatch was reading it to me because he's got this really charming prose. So now all of you need to read his paper once it gets published, or maybe you'll be happy to send it out, I don't know. But, and Kevin, your paper is also extremely well written, and it was a very easy read. I love the historical context of the open network architecture, and actually had a few moments of panic and thinking back to those days at the FCC. So the second point I want to make is we're hearing it over and over and over again, and this is this idea of the social contract having these values. Chairman Wheeler talks about the values. We heard about it first from Commissioner Rosenworcel, and actually we heard about it from public knowledge as well. And these values really haven't changed that much. Those of us that fought the wars of the 96 Act implementation remember them quite fondly or not fondly. So I agree with Paul DeSavin. He says they're pretty much the same. What's changed, of course, is the technology and the number of competitors and the number of providers providing a very similar service that to consumers may not be at all distinguishable, regardless of how distinguishable they are to people who know the technologies. The second point that I would make then is to acknowledge what Kevin asks in his paper, which is, okay, so what is the purpose of this alleged social contract? And is the market not capable of providing the services and the functionalities to meet those desired values, in which case that is when we do need to think about government intervention, which is, I believe, what Len's point was. Kevin also raises in his paper the issue of why do we impose, and I am paraphrasing here because I read the paper and then thought about this later, so you feel free to argue with me, but why do we impose some of these obligations on some providers and not on others? And so I think it's useful to explore why in today's world we have various providers providing similar products, but we aren't regulating them in the same manner despite that. Kevin says that one of the reasons historically this may be the case is because these were private companies that were providing a public utility. Are they still a public utility? And that's just something to consider. I'm not going to answer it. Derek's hedgehogs and foxes analysis led him to one conclusion, which I think we also heard from other folks, and that is that one must take the bitter with the sweet. I'm so glad you didn't say that while you were speaking. So what that, and we've heard this before, you know, there's trade-offs. We all know that if we, well, those of us in the room know that if we take, for example, a cable service for voice service, we may not have the same power backup, or actually we won't have any power that you get through the copper network, and that is a trade-off. We know that if we have a snowstorm, we are going to lose our telephone service. So the question then becomes, when is this something that we need to actually have government intervene to find fixes for the bidder? And when is it a time when we just need to accept that we are going to have a trade-off of sweet for that bidder? Paul called it better or for worse, for better or for worse, but it's the same context. Finally, I just wanted to talk about a little bit of your constitutional analysis. When you talked about one of the questions for listeners is, when is it appropriate for a state to intervene for to implement a certain goal, but then actually do it for other purposes? And you raised the issue of Vietnam, which was introducing regulation of the internet in order to protect, I think it was minors from sexual predators, but in fact doesn't ban pornography on the internet. That is one area of government intervention that is suspect. And I want to turn that a little bit away from the constitutional analysis to talk about why it is that we are seeing foreign regulators trying to impose forced localization laws, data retention laws within borders. I think this is something that we really need to worry about in the international context. We heard the last panel talk about that. Because it is a question of, is this actually protectionism? Is this trying to boost certain competitors over other competitors? And I think we all need to keep an eye on that and make sure that that is not happening in the international context, whether we worry about it in a constitutional context or not. And then finally, I loved the Internet of You that I learned about in the last panel, and I was thinking, well, could we not solve a lot of the problems of reliability if, in fact, we become our own batteries? Thank you.
Winston.
Thanks very much. I wanted to continue on Anna's streak here on constitutional analysis, because I too liked Derek's paper a lot about talking about the First Amendment, and I wanted to discuss some of the case law in the EU on constitutionality of blocking websites and so forth, because it brings up these issues about, you know, striking the right balance between open internet and the social contract in the broad sense. Kevin reminds us that the social contract was invented in France with Jean-Jacques Rousseau, if you had this panel in Europe, they would say, well, the social contract is basically the European Convention of Human Rights. That's our constitution in terms of fundamental values. And so anything we do, you know, it's nice to talk about universal service, but the social contract in the broader sense is doing the right thing under constitutional principles. So there I wanted to talk a little bit about state action, which Derek mentioned in his paper. In Europe, there have been numerous attempts of state action, and many successful, which impose non-neutrality on internet intermediaries of various kinds, search engines, access providers, and so forth. And those attempts at filtering for copyright infringement, for blocking gambling, for hate speech, insulting Ataturk in Turkey, the Turkish government imposed restrictions. Those have all been analyzed by Europe's highest courts under a constitutional balancing test, where freedom of speech, freedom of expression is one of probably the most important value that they balance. But it's not the only one. They also look at privacy, the right to run a business, the right to security, which would justify law enforcement intercepts and so forth. So we have actually in Europe over the last 3 or 4 years a very rich case law that illustrates the balance between state-imposed non-neutrality and preserving what I would call the social contract in the European sense. The other, if we turn then to non-state action, because that's the flip side of Derek's argument. Well, if there's no state action, then you can't really raise constitutional arguments about freedom of speech. That's true in Europe as well, and we recently had a case, for example, in France, where an internet access provider started selectively blocking certain ads, and they claimed it was a consumer protection thing, saying, "Gee, if you come to our network, you won't get any ads." The problem was, and this sort of validates Derek's proposal about the difference between what you say and what you do. The problem was, in that case, the internet access provider, it turns out, wasn't blocking all ads. It was blocking some ads from some ad servers, and it was highly, there were a number of clues that it was doing that for other reasons, for competitive reasons, to punish somebody. And so that, now in Europe, we don't have a no blocking rule or a non-discrimination rule under net neutrality rules. So we had to use consumer protection, general unfair business practice principles to address that, which leads to the idea that maybe this idea that Derek proposes about when you have a real difference between what people say they'll do and what they actually do, that sort of reminds you of in Europe how we deal with privacy rules as well. And I think the FTC does that a little bit too. If there's a real disconnect between what the objective you're seeking to achieve and then what you do to achieve it, there's a disproportionality that renders your action illegitimate, basically. And we saw that in the Google Street View case. Google said, "I'm collecting Wi-Fi coordinates to help provide geolocation services for Street View and Google Maps and so forth." And then the privacy authority said, well, in that case, why are you collecting all the payload? You don't need the payload to achieve that objective. And so it's a thought that you could actually address net neutrality in the same way. And the last point I want to make is about non-state action, sort of unilateral, non-neutral acts by ISPs. What we're seeing in Europe, too, is a risk that governments will urge or suggest or nudge internet access providers to be non-neutral. So it won't be a state action, but it'll be sort of a encouragement for ISPs maybe to give preferred, this came out of a French proposal, maybe you should give preferred bandwidth to internet to content providers who play by the rules under French cultural objectives. And the government hasn't picked that up yet and really run with it, but it was a very serious study that proposed that. So I think that's going to be an interesting thing to watch.
Winston, you were talking to me before the panel began about Netflix in Europe. Is that a separate issue that you want to talk about, or have you?
Well, yeah, I wanted to do that too, because not specifically about Netflix, but any over-the-top content provider, because they're all being hit by the French. They call them the GAFAs, the Google, Apple, Facebook, Amazons, and so the French are trying to figure out ways to either tax them or slow them down or do something, we see that manifesting itself on the ground with disputes coming up on peering. There was a lawsuit in France between Cogent and France Telecom because Cogent claimed that France Telecom wasn't giving any, wasn't increasing its free peering capacity, and France Telecom said, "Sure, I'll increase it, but you got to pay me because we have traffic imbalances." And that went to the Competition Authority and to the Court of Appeals in Paris, and they basically held that peering is a competitive market. It's substitutable with transit, so if you can't get in one way, you can get in another way. So we see the efforts there by ISPs to impose paid peering to slow down these content providers. And then the other way is this risk of, I'd say, voluntary non-net neutrality, which is hard to attack because it's not a government action.
Got it. Let's go to a student question, then I'll ask a question, then with any remaining time, we'll take audience questions if they are enough, and if not, I'll go down my list. So which student wants to start? Yes, sir. If you could just wait for the microphone.
Thank you. My name is Vishal. I'm a master's student in telecommunication. So I have basically two questions, and both questions are basically based on Paul's conversation. So my first question is, like, we are talking about internet, and internet is basically everyone uses it, but nobody owns it. And it basically runs on only one protocol, which is BGP, and which is inherently very insecure protocol. And you were talking about the Pakistan YouTube incident, and that was just one command by one engineer in Pakistan telecommunication. So it's that insecure. In fact, last year there was an attack where all the internet traffic was going through Belarus and Iceland. And in fact, if you were in Denver and you were checking your account, your information was going to Montreal, New York, London, Belarus, and then it was coming back. So we are talking about internet, and internet is that insecure in this like international scenario where every country is using it, but nobody is responsible for that. So what we are doing to secure that, and what we are doing to deal with that problem. And my second question is basically on this slide, which says like we have 5% residential voice, 3% residential voice, and rest of our enterprise and wireless and all those stuff. So if we talk about E911 or like emergency 911 services, only 8% users can be tracked with their location. Rest, we cannot do any dynamic location tracking. We cannot find the internal number of a enterprise scenario. So what we are doing about that? Why we are not doing anything for that? So these are my two questions, basically.
I'll take the second one first. So just because the Charter's share of revenue in the industry, right? And so my point was only that, things like exactly what you mentioned, right? 911 service, super important debate, super important question about how to translate it from TDM world to an IP world to a wireless world, right? I guess all I was saying is it feels like a lot of those discussions affect about 5% of industry revenues. There are IP transitions going on in all the services and products and customer segments and geographical segments that are in the other 95% of revenues also. And therefore, I think those are questions with respect to the IP transition that are worth talking about beyond just the TDM to IP.
Thank you for your question, and I think in response to some of Paul's suggestions, one of the things that we're concerned about, we've seen some recent data that actually NINA did, the 911 organization in California, about some of the issues with location accuracy, especially for wireless. It's a huge issue also in buildings that have large buildings, several floors where they can't tell where you are. But I think one of the things that we're seeing writ large, and what I'm concerned about as a public official, is also not wanting to have just a huge cost shift where it's not like the public duty to respond to emergencies disappears.
Right.
So right now, the network and the duty for 911, the duty for call completion helps to facilitate those public duties. If you made those duties disclaimable or you eliminated those duties, there would still be the public duty, but it would be much harder to carry out. And so you would end up having huge cost shifts. And when we talk about the ability to call 911, it's not just about, my partner is having a heart attack, but there is a fire that may affect lots of people. And, the government, the public has a duty to respond to that. And so that is why we have imposed obligations on these networks. So, both the FCC and states have also made duties like 911 and call completion non-disclaimable. So part of it is, if you are a telephone corporation, and also the FCC said for call completion, they applied this both to one-way as well as two-way VoIPs based on their ancillary jurisdiction. They imposed the call completion reporting and other types of obligations. Now, it's one thing if you're using a over-the-top internet service, there's no duties there. And I think we do see like areas where there's confusion. There are a huge number of people who are texting to 911, and right now we don't have the protocols available to answer those texts. Right now you can't email 911. you need to call. And I would remind us that, like, as much as this is a very techie audience, I'm sure many of you, all of us rely a lot on email as well as texting. When you look even at wireless, the average American today makes about 700-ish minutes a month of wireless calls. It's about 30 minutes a day. So as much as we see, huge amounts of revenue for other things, for the average person, it's 30 minutes a day on average. When you look at some of the carriers that have unlimited plans, for example, Cricket Leap has disclosed that their customers who have unlimited plans make 1,550 minutes of calls a month, about 50 minutes a day. So voice is not dead, voice is still critical, and voice as well as these duties are critical to the public being able to carry out basic public safety obligations that also help to connect families, create economic opportunities so that we don't have, these disconnects in many areas.
So let me ask, I'm sorry, Len, do you want to do this? I was going to ask another question.
I just wanted to make a point that no one should leave here thinking that IP is inherently less reliable than TDM technology. There are issues, there are very important issues that we need to work on as a community. But there's a lot of strengths to IP that makes it much more resilient, right? And you could, it's been terrific in the old TDM world. You could rely on power from the batteries in the central office, right? Well, 25% of people do that today, roughly, across the nation. The other 75%, in the event of an outage, in the event of a hurricane, can't just turn it on because they've already disconnected the service. And are batteries in the central office any better than batteries in the device or batteries in the home or however the future technology is ultimately constructed? I just want to remind people this is a transition. It's going to take years for AT&T by our own projections. We think these are all critically important issues, but we shouldn't leave thinking we're moving from a superior legacy technology to an inferior future technology. I think that's wrong. I think the future technology is superior in many respects, and we just need to recognize that we continue to evolve the process as we move through this transition.
So let me ask a question. It's been noted, but I'd just like to ask people what they think the solution is. And let me start with this. As near as I can tell, everybody on this panel is in favor of IP transition. Everybody is in favor of market-driven competition to that end. But of course, markets don't solve every problem. They're not expected to solve every problem. It's not the function of markets. In one area that a couple of people have noted, the Sierra Nevada as being a leading example thus far, is what happens in rural America, right? Rural America is sparsely populated, which traditionally has been an issue affecting network deployment. Its populations tend to be older. The rate of poverty is higher in rural America than in the rest of America. It's a place where robust broadband doesn't always reach. My wife is an organic vegetable farmer, right? She's got a farm, no robust broadband. So the question is, as a matter of either social contract or social policy, what do we do in a situation if we came to believe that the market wasn't going to solve that problem through no blame of the market, right? Mm-hmm. What should we do, perhaps in an enforceable way, to deal with populations who we think would otherwise not be reached by the kind of advantages, Len, that you describe in an IP-based network? Anybody? Yeah, yep.
Well, so this has been an issue, and the state of California is lucky both because of our size and our leadership. We've put our money on that. We have a California Advanced Services Fund where we've set aside $225 million to promote broadband access in unserved and underserved areas. So an example of that is we recently gave a grant to the Karuk tribe, which is working with the Yurok tribe being our largest tribe in California. They're near Eureka, and so they are now actually building broadband infrastructure. They have some incredibly capable people there, and it's a very interesting mix of issues because so the Yurok tribe is living on native sovereign land. The Karuk tribe, they don't have a reservation, but this is their ancestral land. So once in a while you get these people, like in the call completion proceeding, the FCC put out an enforcement order about unacceptable responses, and they identified one carrier who gave an unacceptable response to somebody who complained about lack of call completion. And the carrier said, "You live in a rural area, you should expect problems." Okay, that is unacceptable. And, this is the native, sovereign, traditional land of these people. They deserve service. They also are having issues. We're trying to finish getting a plain old telephone service to the Yurok reservation. They just got electrical service 6 months ago due to a grant that we gave them, and it took a while for build out. Oh, thank you. I thought I turned it on. So anyway, so we're trying to work with a number of organizations. We also have a consortium where we've tried to develop this. But I would just add the last thing. One of the biggest problems with some of these proposals is IP interconnection. And so one of the reasons why this particular proposal was able to be successful is it was a rural telephone company, Siskiyou Telephone, which allowed the Karuk, who live in part in Siskiyou territory, to interconnect on their side, and a competitive cable company, Suddenlink, which allowed the Yurok to interconnect near Eureka. Without that, this project would have never happened. And so actually one of our greatest challenges is IP interconnection. So as we go away, when you look at IP and you don't have mandatory interconnection, negotiating these interconnections are just absolutely huge. So I think it's a combination of looking at, how can we transform universal servicing, but also how can we deal with these roadblocks to create the robust interconnections.
Which I would argue, that that's the whole purpose of the IP transition trials, or experiments as they're calling them, is to identify these types of issues and figure out how to fix them.
Right.
And I think it's incredibly important that you have this proof of concept trial of the CAF, right? I'm not familiar with the California program, but certainly we should look for the most efficient, least market distorting mechanisms to serve high cost areas and serve vulnerable populations. It won't work to just pick out a carrier and say, this is your obligation anymore, because the competitive market won't allow that in competitive areas where the market's working. But these type of universal service programs that make funds available in a very efficient way are probably the model. Interconnections are obviously critical, and getting there through this process is critical. I think the commercial market will get us there, but we want interconnected networks, we want competition, and we want service in areas that the market won't serve.
Sure, Derek.
Just briefly, one thing that's kind of interesting about this is you have three basic choices for under-provisioning, right? One is that the government can build it itself, and some states have rejected that, right? Municipal Wi-Fi. The second is that you can impose obligations on the carriers to do it. That's just basically a cross-subsidization move where some people pay so that we build out for the others. And then the third is just tax and transfer, which is you build it and you turn it over to the companies, you turn it over to the local government and whatnot. And so I think I agree with Len in the sense that I think when we choose among those, normally efficiency is probably the sort of best way to think about it. The one thing that I think I want us to be really careful about is a lot of people talk about market distorting and regulation distorting markets. That is an important lie that we need to stop saying, right? There is no market without regulation, right? It is an interplay between the two. And so when we juxtapose the two, regulation bad, market good, well, if you ask people who do the other type of IP, they absolutely love the market distortion that intellectual property rules create, right? If we think about local rights of way, that too is a market that's a certain monopoly. So I think we have to be cautious, right? And to admit that it's turtles all the way down when we're talking about regulation. Property and contract law is a form of regulation that allows markets to survive.
So how many animals do we have to remember?
I know.
Question from the audience? Anybody? Yes. Can you just wait for just because it's a webcast, if you wait for the microphone for a second.
I'm just curious about the speaker's thoughts, as we look at these IP trials and the assumption that we need to be getting broadband into rural areas or underconnected places. I work on that every day, and what we find is oftentimes it's trying to get through Forest Service or BLM or other regulations. So in the three, alternatives you've outlined, there's nothing really there that addresses this area of government regulation that is not designed with telecommunications involved at all, that, it takes 3 years to get a permit in a national forest zone, and 70% of Colorado on the western slope is federal lands. So, we get a burden that says we must provide rural broadband. We say, we're going for it. We're going to go get it. Oh, wait, we can't get a permit. So will the trials provide for that? Or, is there a way to look at that in a cross-government manner?
Anybody want this?
Yeah. So just one thing I would mention, the trials talk about applicable permits, although they tended to focus more on state, local, and sovereign nation permits than federal permits. But also we regulate investor-owned electricity and natural gas, and so the BLM has actually been very successful in working on management for renewable resources siting on BLM lands. And so BLM certainly knows how to do this, and I think that is an area for FCC leadership to be able to figure out how do you get to those issues. And the last thing that I would add is that I think that these issues are important because when you look at a lot of these places, the Yurok and the Karuk are both an example where they live, there is no wireless service. There's a little bit of wireless on Highway 101 where the Yurok are, but a lot of the people need to jump in a truck and drive 30 to 45 minutes to be able to call 911. There's no cable out there. They've already developed themselves a WISP. So these are areas where, again, the market has not served them because their population is pretty low and they have very challenging terrain. So I think that's
Kevin and Len?
Yeah, just briefly, we talk about regulation as though it's either government comes in and mandates something or the market just does it on its own. There are a lot of different functions that government can provide, and one important function that the FCC and also to some extent the state regulators provide in some cases is a coordination function. And we see that, for example, most clearly with network reliability, where there's a federal advisory committee that provides that convening function that doesn't necessarily mandate, but brings the industry together. And we're seeing that, for example, on some other areas, other issues as well, beyond what we're talking about here. So what you described is something where, as we go through the set of impediments in these areas, there might be some value in an agency like the FCC that can then talk to all of those different agencies, or maybe if it's at a state level, then it might be something at the state level. That's not necessarily about it. Now, there is also preemption and so forth that sometimes comes into play. But there's not going to be one solution to all of these problems.
And my only point is don't wait for the trials. This is a real problem today. There are people without broadband, there are people with inadequate broadband. There's cost. Different jurisdictions have moved forward towards some than others. But the point is we should be trying to streamline processes, protect legitimate interests, but get these costs down so we can reach these areas that are served today.
And if I could just add something. Thank you. There's two things. One, if I remember correctly, there is an executive memorandum on this very issue, and there's an interagency group that's supposed to be addressing streamlining these types of issues between different agencies and permitting. And then the second is this is going to be a very real issue for FirstNet as it deploys the nationwide wireless broadband network. Their mandate is 100% coverage, not 80 or 60% coverage. So they're going to be dealing with that as well. We'll see who gets to it first.
Okay, we have time for at least maybe only one more. Could somebody John, could you just bring a mic up to Danny? Well, I noticed all these questions about FCC trials. I'm glad that nobody is asking any FCC officials in the room. Danny?
Well, I think I want to ask maybe all the regulators in the room. I'm really wondering how we're going to know whether this question of the transition and the what I think is a critical social policy imperative of universal access, universal coverage, is really being satisfied or not. I mean, under Larry's leadership, NTIA restarted the broadband usage surveys. And I think one of the things you saw in those surveys that continues, first of all, is there's on the order of 30% of the country that's just never used the internet at all. So that's a big number of people. And they're also dispersed, highly dispersed around the country. They don't fit into one category. They don't fit into one demographic, one ethnic group, one geographic area, one type of geography. And I'm really wondering whose job we think it is to make sure that we've actually successfully transitioned. There's very kind of theoretical discussions about what style of regulation would be a good idea. I don't tend to think that matters very much. I think what does matter is that we have some certainty that someone's in charge of making sure this works, so that we don't have like a DTV scramble at the end, which is probably not even sustainable for this problem. So I'm interested in whose responsibility this is really supposed to be.
But I mean, the point you're raising is ultimately a question of how we define success. It's not ultimately a transition question.
Define success. How do you set access?
But is it 96? That's fine.
So my definition is somewhere between 95 and 100% access. You could pick whatever number you want. How do we get there?
Right, but it matters a lot what number we pick, and it matters a lot, and it's asymptotic. So the closer we get to 100, what?
Pick 95. How do we get there?
So right. Well, whose job? It's everyone's job. That's involved. You know? It's not. What I said before is true. There are coordinating functions for certain agencies, but there are a lot of pieces to that, as you described. And some of them are just people who, it's literacy, technological literacy, and in situations like when we had the stimulus grant money, where there could be a process of saying let's tackle various parts of that. That's an opportunity to do that, but as you know all too well, that's not a regular occurrence. So it's this standard kind of process, from the White House on down, who has different roles in this and what roles can they play. It's not something that just one agency is going to fix by itself.
Paul?
Yeah, I think you have to sort of separate out supply and demand side, right? So I mean, if you say on the supply side, to X%, 90% of the country, the market, to Len's point, is going to take care of it, right? There will be either a cable guy or a telco or wireless guy or both, some combination of the above. And then if you're not getting the penetration you want on the demand side, then you can decide whether, well, is this something that we need to subsidize because people can't afford it? Is it an education issue? Is it just a choice issue? So for a lot of the country, let's say 90 out of your 95, maybe there's demand side actions that need to be taken if it's decided that's a social priority. And then you've got the question, which I think is the standard universal service question, about then how do you get from 90 to 90 plus X, where X is whatever you've decided is the social goal and the economically rational thing to do on the supply side, because you've got to subsidize those networks, and you can only subsidize one, because again, to Len's point, there's a market failure there, and so it doesn't make sense to try and subsidize multiple, and then you've got to deal with the same demand side question for the area where you've subsidized the supply side. So I mean, you look at those four supply-demand quadrants and you decide what you want to do. And I think we're in the process of doing that, right? I mean, with respect to universal, Sharon Gillette, who performed universal service single-handedly, more or less, is in the audience here, right? We're in the process of doing that on, I think, the supply side and the demand side with respect to pilots and adoption and reorienting subsidies from pure voice to voice plus broadband.
So we have about 2 minutes left, and I'm determined that we'll end on time because Phil Weiser has told me we must. So let me just ask one question. We can go down fast answers, or people can, but there's been a lot of talk of a social contract. Some people, one of us has labeled it a myth. Many of us have invoked it for its enduring values. As we listen to this conversation, what, if anything, government should it do to enforce the social contract? It seems to me that's the big question, or a big question that comes out of the discussion today. You want to just try to go down quickly and give one-sentence responses?
Just quickly, I think that the important piece that Kevin brings up is that antecedent to that is we have to figure out what the social contract actually means, right? So it's a very nice shorthand, but it involves a lot of things. It involves getting to, for example, it involves efficiency and commitments to markets, but it also involves some sort of kind of democratic inclusion, that we are all better when we share communications technology. And so taking those apart, right, will help us in the way that Paul suggests, look at which ones are in fact being achieved and are achievable in the market space and which ones aren't. And we need government to step in some fashion.
Paul?
Yeah, I think we need to decide which goals we want to maintain in an IP world and recognize that the fact that we're transitioning to IP doesn't really change the nature of enforcement that's required, right? So if you've got a connection, then in a TDM world, you've decided as a monopoly, the fact that you've put now IP equipment on either end doesn't suddenly make it competitive, right?
Yeah.
So I think the social contract and the values are embodied already in a lot of laws, both federal and state laws, and that those laws have transcended beyond social contract into legal obligations that are enforceable and that have enforcement power. So I think that that's going to be an important distinction as we continue going forward. And also that Len, if AT&T is interested in connecting, I know a lot of people would love to interconnect.
Kevin?
We need to stop just invoking social contract as a mantra, but do the hard work of talking about exactly what it means, what are the values, and what are the trade-offs. And then to the extent we're comfortable with the trade-offs, then go forward with it.
Len?
And first, we are very interested in connecting. It will look very different than the models today, just because IP interconnection will take place in a handful of locations around the country. But to the point of the values, and I'm not sure social contract is the right term, but there are definitely public good objectives that we need to meet, if we will meet. I agree that we see in this environment what the marketplace solves, and what the marketplace doesn't solve. And to the extent you need regulation, my mantra is efficient, streamlined, universal service, lifeline, whatever it is. Some of the models we have today are very difficult to work with, and they don't reinforce markets where they can. So let's try to streamline those places.
Good, thank you. Anna?
Just one component of it, I think it's important to have metrics and to have an availability to measure those metrics. And one that Danny raises is a very important one, and that is that we need to continue to measure broadband adoption and also why it's not happening. That was also very helpful in the DTV transition, was to figure out, okay, we only have 5% of households left. Why aren't they switching over or getting the set-top boxes? So I would say that's an important function for government.
Winston?
Yeah, social contract on the European side, we're struggling with how to adapt audiovisual regulation to the IP transition. And there you have to make kind of a spectrum on the social contract about stuff that's really important and then stuff that's trivial, because we have democracy, plurality of opinions, media objectives there, and then we also have trivial stuff like protecting French cinemas.
Great. Thank you, everyone. Let's thank our panel. We'll be back at 3:15 for the next discussion. Thank you very much.
I enjoy